Palestinians under occupation, it is especially important that we begin by honouring the First Nations of this continent. The struggles of First Nations and Palestinians are distinct, yet they share resonant themes of dispossession, resistance, survival, and the preservation of identity and culture in the face of settler colonialism. May today's conversation deepen our commitment to justice, dignity, and solidarity, both here and abroad. This land was and always will be Aboriginal land. So I'd also like to take a moment to acknowledge some special guests and members of the legal profession in attendance. So today we are honoured to hear from Professor Chris Sidoti on his work with the United Nations Human Rights Council's Commission of Inquiry into the human rights situation in the occupied Palestinian territory and Israel. Before we introduce him in detail, I would like to acknowledge that this event is part of the Palestine Project, a law school initiative that brings together students and staff committed to understanding and responding to global justice, especially in relation to Palestine, through legal education, community support, and critical engagement. I'm also pleased to introduce Professor Chris Michelson, Associate Dean Research and Professor of International Law, who will be moderating this panel this evening. So to formally open this event, I will now invite Professor Catherine Renshaw, who is the Dean of the School of Law and Professor of International Human Rights Law, who is joining us online today from Shanghai.
Good evening, everyone. It's a pleasure to be joining you, even briefly this evening. I'm here for a conference on the rule of law, and my panel with fellow law deans from China, India, and Singapore is about how we educate law students about the rule of law. The discussion I'm about to have with my fellow deans connects with the event that you're about to participate in this evening, because it is at its core about the international rule of law. It's been difficult looking at a string of global events in recent years to believe that the rule of law exists at the international level, or that the phrase has any meaning. It's not unreasonable to conclude that we've stepped back to a time when strong states are doing as they will and the weak are suffering as they must. But one of the darkest developments of recent years has been the attempt to distort the truth by powerful states with lies and disinformation that try to uphold a narrative that states are just acting as the law says they can, and that the weak's suffering is just an inevitable and justifiable secondary consequence. In the wake of protests across our campuses in Australia and around the world last year, students explained what motivated them to leave their classrooms. And they said that they were motivated by the outrageous suffering of the innocent, but also by a deeper fury at what they saw as an attempt to gaslight them on an epic scale about the atrocities, about the law, about the fact that international law does in fact prohibit some atrocities. So in that context, it became very important that this law school carved out a space that by its very existence maintained two important things. The first is that there is a universal moral code that has at its core freedom and the prevention of suffering, and this code has been translated into international law. And that it is possible, even in the face of intense conflict, to work out what the truth is. But of course, none of those things mean anything unless there are lawyers with enough courage to stand up and say what the law is and what the facts are. And it's wonderful that the speaker you have with you tonight, Professor Chris Sidoti, is awash with exactly this sort of courage. Chris is a human rights lawyer, an advocate, a teacher. Since July 2021, he has been Commissioner of the United Nations Human Rights Council, Independent International Commission of Inquiry on the occupied Palestinian territory, including East Jerusalem and Israel. He still sits as a member of the Special Advisory Council for Myanmar, and he was a member of the UN Human Rights Council's Independent International Fact-Finding Mission on Myanmar between 2017 and 2019. He has been an Australian Human Rights Commissioner and a Law Reform Commissioner. He was the independent chair of the United Kingdom and the Northern Ireland Bill of Rights Forum. He works for the Asia Pacific Forum of International Human Rights Institutions across the region. And he's worked for non-governmental organisations, including as the Director of the International Service for Human Rights based in Geneva. I'm going to leave you now in Chris's hands and go off to chair this panel. I hope you have a wonderful evening and a wonderful discussion, and thank you very much for being here to support tonight's event, because even just your presence here is a small step forward for truth and for law.
Firstly, although Catherine's gone, I start by thanking her for the introduction. When Catherine talks about the things that I've done, it sounds like a lot, but you need to make allowance for the fact that I'm very, very, very old. And so when you get to be as old as I am, you've done a few things here and there. I live on Gadigal country, and so I come to different country when I come to Parramatta. And in coming to different country, I acknowledged and indicate my admiration for the traditional owners, those in the past who have preserved this country and cared for it, and those who do so today. Tonight we're discussing Palestine. But I need to start by saying where this Commission of Inquiry comes from and where it fits in before I talk about what it does. The United Nations Human Rights Council is a political body. It's a body that is made up of 47 states, that is countries, that are elected to 3-year terms on the Council by the UN General Assembly. The Council meets in Geneva, it meets 3 times a year, and it operates not only directly itself, but through a number of independent mechanisms that it establishes to work, as the name implies, independently on human rights issues. Perhaps the most well-known of the mechanisms of the Human Rights Council are the special procedures, the special rapporteurs, who are appointed to look either at thematic issues like freedom of speech or country issues, such as the occupied Palestinian territory or Myanmar. The Commissions of Inquiry are a different independent mechanism established by the Council. They are predominantly independent, investigative mechanisms, with the emphasis particularly on investigation. They can carry a number of different names, and that's political. It can be, as ours is at the moment, Commission of Inquiry. It can be, as the one on Myanmar that I was a member of, was called a fact-finding mission. There can be independent expert groups or independent eminent experts. Different names depending on the politics at the time, but essentially all having the same functions. The functions are to investigate, to form conclusions on the basis of the investigations, and to make recommendations. And these functions are pursued through reporting publicly about the investigations, the conclusions, and the recommendations. Our Commission of Inquiry has those functions, like all similar bodies have. But in recent years, the Human Rights Council has added a fourth area of activity, and that is the promotion of accountability. And the terms of reference of our Commission have placed particular emphasis on accountability. We are specifically charged with identifying those who are responsible for any violations of international law that we find, to identify them, and then to work with international courts and domestic courts exercising universal jurisdiction to ensure, or at least promote, accountability in respect to those persons. So the accountability function is an important function and is additional to the traditional functions that commissions of inquiry like ours have. And they have resulted in us working very closely with courts. As Catherine indicated, our commission was established in 2021. The resolution to establish the commission was passed at a special session of the Human Rights Council in May 2021, a special session devoted to examining the issues from the escalation of conflict in Gaza in May that year. It's important to remember that. The conflict that is continuing now didn't start on the 7th of October 2023. It had been going on for a very long time before that. Our establishment was not directly related to what happened on the 7th of October 2023 and following. It arose from an earlier escalation of conflict, and in turn that resulted from, has its origins in what is now almost a century of conflict in the area that we now call Israel and Palestine. We commenced our work later in 2021. The UN is a really slow body. The resolution was passed in May, but we were not in a position to start work until November. But since then, November 2021, the Commission of Inquiry has been very busy indeed. We delivered our first reports in 2022, and we have continued to report frequently since then. We are required under our mandate to make 2 official reports a year, one to the Human Rights Council in June and one to the General Assembly in October. But we are able to produce additional reports or supplementary reports. One difficulty with the UN system is that those 2 official reports are strictly limited in relation to their length. There's only so much you can say. They used to be limited to 10,700 words, so about 21 pages. That's been reduced by 10% this year because of the UN's financial crisis. And so most of the substantial work that we do is found in the other documents we produce around those formal reports. We started off, as required by our terms of reference, in looking at past reports on the situation in Palestine and Israel, and commenting on the implementation of recommendations that had been made in the past. We found that past reports had made very serious findings and very good recommendations, most of which had not been implemented. We moved on from that to examine the contemporary situation. And so we looked at the lawfulness or otherwise of the occupation in our first report to the General Assembly. And we came to the conclusion that the occupation was unlawful and the policy of settlements was unlawful. We said this is our conclusions as a formally established official body, but we said that these issues are so fundamental that they should be examined by the International Court of Justice. And we recommended to the General Assembly that the Assembly ask the Court to provide its view on those questions. Now that's one recommendation from an official body that was accepted. I got to say, on that occasion, I was surprised at how quickly the system acted. Within 6 weeks of our making the recommendation, the General Assembly had made the referral to the International Court of Justice. And within 8 months, the International Court of Justice had taken up that recommendation and started acting on it, and a year later produced its opinion. In 2023, we examined the situation of civil society in Palestine and Israel. We looked in particular at the declaration by the Israeli government that 7 Palestinian non-government organisations were terrorist organisations. We found that there was no basis for that decision by the Israeli government, but there was no evidence to establish that these very active, very credible human rights non-government organisations were terrorist organisations. But we looked more broadly at questions of civil society. We were particularly concerned in that report not only about those 7 declared terrorist organisations, but also at the harassment of women journalists by Palestinian security officials. We had evidence that women journalists were particularly targeted for shaming on the internet as a way to discredit them and the work that they were doing, particularly when they were examining human rights violations by Palestinian officials. Our second report in 2023 to the General Assembly looked at the use of force and law enforcement, particularly by the Israeli security forces. We examined in particular the killing of Shireen Abu Akleh, an Al Jazeera journalist, a Palestinian American, and we found that her killing was either intentional or reckless, and in both cases would constitute murder. We had no sooner completed that report than the events of 7 October 2023 occurred. That happened only 3 or 4 days after we had adopted a 2-year work program for 24 and 25. That work program was immediately put on hold, and our attention necessarily was directed towards what happened on the 7th of October 2023 and since then, and continuing. Since June last year, we have produced 6 reports on the events of 7 October and following. In reports that we delivered to the Human Rights Council last June, we examined the events on that day itself, and we found that the Palestinian armed groups were responsible for the commission of war crimes in southern Israel on 7-8 October 2023. In another report issued at the same time, we examined the actions of the Israeli security forces in Gaza and the West Bank from 7 October till the end of 2023. And we found that the Israeli security forces were responsible for the commission of war crimes and crimes against humanity. Those reports in June went to the end of 2023, but since then, of course, we have been continuing our investigations and continuing our reports. In March this year, we produced a report on sex, gender and reproductive violence at the hands of Israeli security forces, principally in Gaza, but also in the West Bank. We looked first at the disproportionate impact of the Israeli violence on Palestinian women and girls. Here we were struck not only by the enormity of the numbers of deaths and injuries of Palestinian women and girls, but also at how the patterns of those killings had changed during the course of the many periods of heightened violence in Gaza over the last 20 years. The proportion of fatalities who are women and girls has doubled during that period. It's gone from something like, let me just get the exact figure for you. It's gone from 15% in the escalation during 2008-9 to 33% in the current period of fighting. 33% of fatalities are women and girls. If we include boys and look at the fatalities amongst women and children, it's around 60%. And an enormous number of civilian casualties in any conflict. And certainly part of a steadily increasing proportion of casualties amongst those who are most innocent and most vulnerable. When we examined why this was occurring in this particular round of fighting, it seemed to us that there were two principal causes. The first is the targeting of residential buildings and buildings in which displaced persons are living, far more than in the past. In the past, the targeting was much more directed towards those facilities that were somehow related either to the military role of the armed groups, particularly Hamas, but also the political administration of Hamas, which, as you know, has controlled Gaza since 2007, 2006. Now residential buildings, hospitals, schools are being targeted like never before. And these are places where women and children are concentrated, rather than in official military, quasi-military or political areas. Targeting places that concentrate women and children inevitably results in more casualties amongst women and children. The second factor was a change in the rules of engagement, the operating procedures of the Israeli military that accepted a higher proportion of civilian casualties, the so-called collateral damage, in making decisions about targeting. The Israeli military likes to pretend that it's a modern, moral military force, and so it has rules of engagement. And part of these rules of engagement is a formula about how many possible civilian casualties can justify the killing of one person. A certain number in the case of ordinary fighters, a much higher number of civilian casualties tolerated in the case of leaders, those in military command positions. It's operated with that kind of formula for a long time. But the rules of engagement changed with this fight, and the tolerance of civilian casualties is much higher now than what it was in the past. And so military commanders can accept higher levels of civilian casualties now in making decisions about the targeting of aerial bombardment, tank fire, and ground operations. Now, these factors have not only resulted in much higher civilian casualties, but also much higher casualties amongst women and children. Second, we looked at particularly gendered dimensions of the fighting that has taken place. And here there are different practices in relation to women and girls from men and boys. But sexually targeted violence occurs in both cases. Men and boys have been subjected to significant sexual harassment, sexual intimidation, and sexual assault, including extreme cases of sexual assault in Israeli detention. Some work has been done by Israeli investigators that has been groundbreaking work about the practices in Israeli detention centres, particularly the military facility at Sde Taman. These practices have changed from what they were in the past. We took evidence from two Israeli lawyers who have acted for a long time for Palestinian prisoners and detainees. And they described to us what their clients have said to them about what happened. We can't talk directly to their clients because they're in detention and the Israelis won't let us. But the clients authorised the lawyers to speak to us, and they told us what had happened. Perhaps the most significant thing they told us was that they had been acting for Palestinian prisoners and detainees for a long time. There had always been information given them by their clients about extreme sexual assault. But it had seemed before 2023, 7 October, that the incidence of these practices was limited, that it tended to be fairly random, and it was very individualised. Now, they said, it was widespread, perhaps universal, and more extreme. That it was clearly because it was widespread and the practices were common across a number of facilities and many clients, it was clear that this had become part of the standard operating procedures of the Israeli security forces. These things, at the male side of the spectrum, were being done to boys and not just to men, so children. Our report also looked, for the first time in any UN report, at reproductive violence. And that is the specific targeting of the reproductive capacity of the group, in this case Palestinians. And we found that there had been specific intentional targeting of Palestinian reproductive capacity. Perhaps the most dramatic was an attack on the largest fertility clinic in Gaza. A clinic that was clearly identified as a medical facility, clearly identified as a fertility clinic, that was targeted with tank shells, and so not from the air, and so all of the markings were clear and apparent. The destruction there was of 4,000 embryos and 1,000 items of reproductive material. That means eggs and sperm that had been saved and preserved. The facility essentially was wiped out in terms of its capacity to provide fertility treatment for Palestinians. That perhaps was the most dramatic because it was a large and well-known fertility centre. But equally concerning is the fact that maternity wards were targeted in the hospitals that were attacked. An earlier report of ours indicated that we had found that there was a concerted program of destruction of healthcare facilities in Gaza and the capacity to provide health services. But within this overall concerted program, it was clear that maternity wards in hospitals and neonatal wards were being specifically targeted as well. And so we found a destruction of reproductive capacity, and in that case, we expressed the view that these constituted acts within two categories of genocidal act. That was not a finding of genocide, it was a finding of genocidal acts. Our work continues. That report was released in March. Our next report will be released next week or the week after. It will deal with the destruction of cultural property, principally educational facilities and services, but also religious sites, archaeological sites, museums and libraries. And it will discuss that in terms of the capacity of the Palestinian people to maintain their identity and to undertake, to exercise their right to self-determination. I mentioned briefly then that we had found in relation to reproductive violence 2 categories of genocidal act. The big question of genocide is something that we have not yet expressed our view on. I can go into that if you want to later, but it is something that is on our agenda, and we will be releasing a report once we have completed our analysis, a very lengthy report on that subject later in the year. Our work continues. Our work continues while the violence continues. We are concerned about accountability. We are working closely with the International Criminal Court and the International Court of Justice. At least through those forums, we can seek a stronger legal decision about what has happened and what is continuing to happen. For us, accountability is not just about the past. It's important to deal with the past. Those who are victims of such grave human rights violations are entitled to justice. And so accountability is about providing justice for things that have happened in the past. But equally important, accountability is about the future. One of the reasons why the Israeli military continues along this path of human rights violation is the fact that it has enjoyed total impunity, that it has been able to get away with whatever it wants. Now, it's only when we see accountability that we can expect to see better conduct on the part of the Israeli political leadership and the Israeli military leadership and soldiers and others on the ground. The arrest warrants for Netanyahu and Gallant are important measures of accountability, both for the past and for the future. And that's why they have to be executed, the warrants carried out, so that that accountability can be ensured. I talk, as I always do, far too long. I'm happy to have some discussion with you, either about what I've said or about things that I haven't said. So, over to you.
Good evening, everyone. Thanks very much, Chris, for your remarks. I see Michael wants to join in the conversation as well, but if we could ask for a bit of patience, Michael. Before we hand out the mic for a Q&A session, so it's my pleasure, as Maria said, to co-moderate with Maria the rest of this evening. And before we open up for general Q&A, questions and answers, we'd like to follow up very briefly about a few things that Chris has said in his remarks. And so I have a few follow-up questions, I think, on what he has touched upon, and to which I'd like to invite him to talk a little bit more about in detail. And Maria has some questions as well, and then we open up. So I might just take the prerogative and ask actually the first question, Chris. And my question is really a general question. So I think you very nicely explained the mandate of the special procedures of the Human Rights Council. It's not the first commission of inquiry. There have been many. So this is where I think my question really is sort of based on. So often these commission of inquiries are sort of in between a rock and a hard place, if you like. They are criticized, or their work is criticized from opposing sides. And in your case in particular, I think there's, on the one side, there are those who accuse the UN in general, the Human Rights Council in particular, and your commission even more in particular, of an anti-Israel bias. On the other side, there are then those who say, okay, well, the commission of inquiries don't really have teeth. They and in what they do, And notwithstanding, I think, the important points you made about accountability and your contribution to accountability, an argument is made that these commission of inquiries really don't make a difference, and they don't change things on the ground. The killing is ongoing, and this is not something that is germane, I think, to this particular conflict. It's similar accusations have been made in the context of North Korea, in the context of Myanmar, in the context of many of several commission of inquiries in relation to atrocities committed in Africa and parts of Africa. So my question really is, how would you respond to either of these opposing sides, and what does the Commission, in your work as a Commissioner, do to address these criticisms?
Because Michael's already got his questions and wants to go, I need to be very quick in responding to the other questions. So I'll try and be faster than I normally am. Yes, supporters of Israel say the UN gives too much attention to Israel. The UN has to give a lot of attention to Israel and Palestine. The UN is where it all started. The UN in 1947 passed the resolution that said that the British mandate should end and that it should be replaced by two states. One Israeli, the other Palestinian, living side by side in peace and security. So it all began with the UN, and ever since then, now for whatever it is, 78 years, the UN has had responsibility for it. It can't walk away from what it began. We can debate whether that original resolution was a good idea or not. But what we can't debate is that the UN has been there from the beginning of this mess. And the UN has a responsibility to try to resolve it. So I reject the idea that says that the UN shouldn't be interfering like this. It is and has been intimately involved for almost a century. The other criticism you mentioned, these commissions of inquiry are ineffective, yeah. I feel this every day, every minute of every day. And I have said many times, and I'll say it again today, we've been working for 4 years. We have been looking at what's gone on in Gaza and southern Israel since the 7th of October 2023 for the 19 months since it happened. I cannot say that one single child is alive today because of our work. And no matter how much I can feel pleased that the courts are taking our work seriously, that the international system has to deal with our reports, I can feel pleased about that. But I can't feel in any way satisfied with our work when I know that not a single child is alive because of us. What I also know, and for this I go back to work I did here 30 years ago. I was a member of the Human Rights Commission, a commissioner there, when the Commission did its report on the stolen generations of Indigenous children. And when, as one of the commissioners, I was conducting hearings for that work, Indigenous people said to me and said to all the other commissioners, this is the first time that we have been able to tell our story, and the first time that what we have experienced has been officially acknowledged. And our report was similarly received. You know, yesterday was Sorry Day. Yesterday, day before? What's the day? Yeah, 28th. Sorry Day is the day in which that report was tabled in the Federal Parliament. And it's 30 years later. It is still commemorated because Indigenous people have said how important it was to have the history recorded. Now, if nothing else, you know, this is my fallback position in my depths of despair. If nothing else, then recording what has happened is important. It's important to the people to have the historical record set so that this cannot be contested. And that at least is something we can do.
Thanks so much, Chris. I definitely agree with you. I think your role is very, very important, and it is the least that you can do is have that recorded. Just on that note, I also know that over the course of your career, you've also investigated other human rights atrocities, including in Myanmar. Have you, geographical and political differences aside, do you see any patterns in the way that those atrocities have been committed?
It's a question I've thought about, Maria. There are always elements of power and greed and I don't know how you describe it, ethno-superiority, racial superiority. Concepts of race are crazy. So let me say ethno or cultural superiority. I mean, these are there. Perhaps it's the question of power that is the most fundamental issue. I don't know what drives human beings to want to have power over others, but that seems to be a common factor in all of these situations. And that's why the law is important, because the law tries, unsuccessfully, but it tries to constrain the exercise of power.
Yeah, no, I completely agree with you, and I think as lecturers at the law school, that's something that we really do teach our students. On a slightly different note, we were talking earlier, just before the session began, that obviously, you have a lot of media spotlight now, but you're also appearing in a lot of different forums. Based on your experience in presenting these findings in various forums, what practices have you found most effective in fostering an open, respectful dialogue? Because obviously there's a diverse range of audiences, and arguably these issues could be politically sensitive or emotionally complex. So.
You're both lawyers. I think most people in the room are lawyers, I guess. Not all. Good. That's good. I'm a lawyer. And, for that reason, what is most helpful to me are fact and law. We need, I have no problem with emotion. I get really emotional about this stuff as well. But we need to find a common basis for dialogue, and fact and law constitute that basis. And so, again, going back to the earlier questions, Chris and Maria, that you asked, the work of our commission is part of the process of finding fact and applying law. And maybe it's my legal education, but that basic legal methodology to me is the most important thing, where we can try to break through prejudices, preconceptions, increasingly false facts, misinformation, to say this is the fact, this is the law, and these are the consequences.
Chris, I'd like to follow up with my theme about the relevance or not of the work that you're doing from my first question, and set this sort of against a broader debate I think that we're witnessing and that we're struggling with, I think, as international lawyers, as human rights lawyers, as good international citizens, to use a term that Gareth Evans used actually here in this forum about 2 months ago, what it means to be a good international citizen. I have two questions. I think one you've already answered. I'll raise it nonetheless, but I think I would like to invite you to reflect on the second question. And so, just to set the scene a little bit, many argue that we're now sort of in the twilight of the UN-led international rules-based order system of the rules-based international order, where states continuously ignore international law. Where rules of international law are not enforced. You mentioned in your remarks as well that the UN is facing a budget crisis. which is exacerbated by obviously a recent executive order signed by President Trump in Washington for the US to withdraw once again from the Human Rights Council, to probably threaten to withhold funding of the United Nations, and obviously the US is the single most important donor to the United Nations. You mentioned that your reports have already been cut by, I think, 10%, you said, in terms of size, but especially also the Office of the High Commissioner for Human Rights, which is the UN office that supports the work of the Human Rights Council and the special procedures, is facing, I think, a massive budget crisis. So my question really is, the first question I have is, why does the work of the Commission of Inquiry still matter? I think you've answered that partly with, I think, a very powerful reference to accountability. And I also agree. I think that the least we can do is to at least, I guess, record what's happening. But I think the second part of the question is, how do you see that work as being, to be sustainable? And how can you, in the budgetary climate, in the political climate, how you can actually carry on with that work?
These are foundational questions. I mean, they go right to the core of international laws. I hope some of you who are students are studying international law, and I hope you actually have a future. It's the darkest days. And I have always been excited and inspired by the great project that began after World War II. The phrase "never again" you hear all the time, but the expression of that in legal terms was the international legal system that has been slowly constructed over the 80 years since the end of World War II. We now have an extraordinarily expansive, well-grounded, well-drafted body of international law. And we didn't have that 80 years ago. We now have some excellent international judicial mechanisms for international law. The International Court of Justice, the International Criminal Court. We have understandings about the responsibilities of states under the law. And those responsibilities supposedly enforced through the exercise of universal jurisdiction by national courts. I mean, the system is there. And when people have expressed to me their frustrations about the system, I've always compared it with the development of the civil law system. We've got here, we say we've got good courts in Australia, and I think we have. And we've got good law enforcement in Australia on the whole. But these didn't come overnight. There's around about 1,000 years that it took through our English colonial masters to develop this from the early 1100s and 1200s. It took a damn long time. And part of the consolation I have is that the development of international law and mechanisms has proceeded far faster than what the development of our domestic mechanisms did. It's been going on at quite a prodigious rate by legal standards, historical standards, over the last 80 years. But it is all teetering on the brink of total collapse. This has not happened overnight. It's been going on for a while. It's been going on domestically and internationally. One domestic example is the treatment of asylum seekers, which, although the High Court keeps on ruling on this subject, successive governments have just not given a damn about compliance with domestic or international law in relation to asylum seekers. So this kind of cavalier disregard for law has been growing for the last couple of decades. Maybe it's because I'm so immersed in the issues with Palestine, but I am becoming more and more concerned that what happens with Gaza will be the make or break for international law. I don't know whether international law can survive the indefinite continuation of what is happening in Gaza.
So I'm afraid I have to slightly disagree with you, Chris, not least because of potentially having students in the audience who want to do my public international law course in semester 2. So please still come to the course. But on a more serious side, so I mean, I share your concerns. I do think we're in for the long run. We have always been in international law, in human rights law. International law has been around for 3,000 years or more in terms of fundamental principles of actually how to treat prisoners of war, how to behave on the battlefield. And I do see, I'm writing, I think, a controversial piece which is called The Future of the International Rules-Based Order is Bright, just to overstate the point. But the work that you're doing is unprecedented in history, right? So you're doing as part of the Commission of Inquiry. It's unprecedented that a state from the global south, South Africa, is bringing a case against Israel before the International Court of Justice. It is unprecedented that we have an international criminal court, the political difficulties, challenges, and procedural challenges notwithstanding, that is investigating individual international criminal responsibility for genocide, for war crimes, and the like. So I do think if we, I fully share your frustrations, and I think, and your pessimistic outlook with respect to certain aspects. But I think if we're taking a historical look at where we are now, we are not in a bad space, as absurd as that sounds, in light of the atrocities that are committed in Gaza on a daily basis, in light of another ongoing genocide in Sudan, in light of the large-scale violations of international humanitarian law in Ukraine and elsewhere. So, and I do think international law, there is a role for international law, and I think it is, as you pointed out, for lawyers, domestic and international law likewise, is to point out what is the facts and what is the law, and how does the facts match up with the law. And that brings me to the final question before opening up to what we have, I think, is half an hour, good half an hour for general discussion and questions. And that is, how do you see the role of the Australian government in all this? How can the Australian government support the work of the Commission of Inquiry, if it can? Has it done so? Or what would you, if you had sort of a wish list to take to the new government, to the Foreign Minister, to the Prime Minister, to the Attorney Generals, what would be on that list?
Are you asking that on behalf of the Prime Minister?
I'm an apolitical commentator.
There was a story on ABC News as I was driving out, where a journalist asked Albanese today, what more is the government going to do to take action in relation to Gaza? And the Prime Minister said to the journalist, well, what do you want me to do? And the journalist said, I'm not sure. And the Prime Minister said, well, there you have it. So I'm going to assume that you're asking this question on behalf of the Prime Minister, who has a genuine desire to know what to do.
I would not ask a question to you on behalf of the Prime Minister, but I would respectively ask you to give some very poignant advice to the Prime Minister.
And I'm not going to talk about my wish list, I'm going to talk about what the law requires. Because it's not just my wish list here. I go back to the lack of response to the advisory opinion of the International Court of Justice last July. The International Court of Justice said that the occupation is unlawful, the settlement policy is unlawful, that Israel should desist from the occupation as rapidly as possible and evacuate all of the settlements, bring all of the settlers back into Israel, and should pay compensation to Palestinians who have suffered damage as a result of that. The court didn't stop there, however. It said that these are violations of fundamental obligations under international law. For the lawyers, peremptory norms that are applicable erga omnes. The court said that the UN General Assembly and Security Council should decide what should be done, but in addition, individual states have an obligation under international law not to aid or assist the continuation of the illegality. Now, that should have prompted an immediate, thorough, urgent review of all aspects of the relationship between Australia and Israel. To firstly, identify what the nature of those relationships are. Secondly, to ask the question, to what extent do any of those aspects aid or assist the continuation of the unlawful acts? And third, to determine that aid and assistance should be discontinued. The court instanced areas in which the examination should take place: political and diplomatic support, economic and financial support, arms trade and weapons support, cultural support. Now, I have no knowledge that this review was ever undertaken. Its results should have been made public, and certainly there has been no public explanation of the consequences of any review, but I don't think it even happened. Now, the court has said explicitly, this is rule of law stuff. All states have this obligation not to aid or assist. This is not a matter of putting pressure on the state of Israel. It's a matter of possible complicity by third states, not Israel, not Palestine, third states, in the continuation of unlawful activities. So the first thing that I would indicate to the Prime Minister is that there has been an obligation since last July to look at whether Australia is in any way aiding or assisting the continuation of unlawful activities, and then to take action to stop any aid or assistance that is being provided. We have a defence attaché in the Australian Embassy. We have an Australian Trade Office in Jerusalem. We don't, as the Foreign Minister and Prime Minister have repeatedly said, provide arms directly to Israel, but we do provide components to the United States which are provided to Israel. We do sell what are called dual-use items to Israel, and that is items that can be used for civilian or military purposes. And we do purchase information, technology, software and equipment and surveillance equipment from Israel for use here, which puts money back into further research and development of surveillance and IT software which is used against Palestinians. I mean, the facial recognition software is being used in Gaza all the time, and increasingly on the West Bank as well. So it's not a wish list. It is a legal obligation that Australia has under international law not to aid or assist the continuation of illegality. And I would say to the Prime Minister, start by obeying the law.
We have now about 28 minutes. Can you hear me? We have 28 minutes for questions and answers. So I was going to invite Michael ahead to ask his question, but I think he has since left and asked Jacinta to ask the question on his behalf. So I might hand over my mic to Adrian.
Thank you. So Michael's given me the pleasure of asking his questions on his behalf. And
I can't believe that he walked out before he asked his own question.
He sends his apologies, and I can't say this with Michael's gravitas, but I still know. So I think you've sort of addressed this in your last comments, but one of the questions, and there are two, just be forewarned. The first one is that, isn't it true the atrocities that you're describing really just couldn't have happened without the support of Western governments? So a question on that side of the accountability that you've been talking about. And the second question is that is there really a genuine prospect of the war criminals being held accountable in the processes that you've described? Thank you.
Could it have happened without the complicity of Western